All right, folks, listen up. Florida just dropped a legal shift that's going to make a lot of people rethink how they carry and how law enforcement reacts. This isn't clickbait or pundit drama. It's a court decision with real teeth, and it changes how open carry is treated on the ground. I'm going to walk you through what actually happened, why the ruling matters from a constitutional and practical standpoint, and the immediate, everyday consequences for somebody who carries. No shouting, no political theater, just the facts, the likely fallout, and the practical steps you should be thinking about right now. If you carry, run a business, or work in law enforcement, pay attention. The rules of the road just shifted, and you need to know where you stand. To understand how we got here, you've got to rewind a little. For decades, Florida carried a strange contradiction. It was one of the most pro-Second Amendment states in the country, yet open carry was still treated like a public threat. You could legally carry concealed with a permit, but the second that firearm was visible, boom, you risked a misdemeanor or worse. That contradiction finally caught up to the courts. A man named Stanley Victor McDaniels became the face of that challenge. He was arrested after his firearm was spotted during a routine encounter, and instead of pleading out like most folks do, he fought back. His legal team argued something simple but powerful. The state's ban on open carry directly violated the constitutional right to bear arms. Fast forward to this year, and the First District Court of Appeal agreed. Not quietly, but decisively. Their opinion said that Florida's restrictions couldn't stand under the same logic the Supreme Court laid out in the 2022 Bruin decision. In other words, unless the state could prove a historical basis for banning open carry, which it couldn't, that law was unconstitutional. The ripple hit fast. Within days, the Attorney General's office issued a memo instructing law enforcement agencies to pause enforcement of open carry prosecutions while they review implementation. And that's where the confusion exploded, because some counties complied immediately, others refused, and Florida ended up split between two interpretations of the same law. So at this point, technically, yes, open carry is legal statewide under that ruling. But in practice? It depends on the badge standing in front of you and whether that department got the memo. Here's where it all got messy. The court ruling didn't rewrite the statute overnight, it just cracked the door open. And every county walked through it differently. Some sheriffs wasted no time. They briefed their deputies, told them to back off open carry arrests, and made it clear that if nobody's acting reckless, it's not their problem. But a few counties dug in, saying, until the legislature changes the law, we're enforcing the old rule. That means what's legal in one zip code could still get you cuffed in another. Not out of bad faith, just confusion. Some departments are following the memo from the Attorney General, others aren't. So right now, Florida's patchwork. You can drive an hour, cross a county line, and go from totally fine to criminal suspect without even realizing it. Until lawmakers fix it, the smart play is to stay informed and stay calm. Now, even with the ruling, private property rights didn't disappear. Businesses still make their own rules, and that's where things split fast. Publix quietly said they'll respect the new interpretation, as long as carriers act responsibly. But Walmart, Winn-Dixie, and Sam's Club went the other way, sticking with internal bans to keep customers comfortable. It's nothing new. Every time carry laws expand, big brands panic about optics. So today, you might see a plaza where one store welcomes you and the shop next door calls the cops if they spot a holster. The takeaway? The ruling protects public carry, not private turf. Once you step onto someone's property, their rules rule. Respect the sign, walk away if asked, and avoid turning a legal win into a trespassing charge. Now, before anyone starts thinking this ruling gives them a free pass to carry anywhere, pump the brakes. Florida's still got a list of what we call no-go zones, and that list didn't vanish overnight. You still can't open carry inside courthouses, schools, government offices, polling places, airports, or any facility under federal regulation. Those zones are locked down under state and federal law, and this ruling doesn't override them. If you walk into one of those spots strapped, you're asking for a felony charge and a one-way trip to booking. Even outside those areas, there's another rule that a lot of people overlook: brandishing. Just because open carry's temporarily protected doesn't mean you can display your firearm in a way that causes public alarm. If you're intentionally drawing attention, that's still illegal. And yes, they can still arrest you for it. Now, here's where it gets tricky. Some private venues operate in gray territory. Think sporting arenas, amusement parks, or public universities. They're technically open to the public, but managed by private entities that set their own policies. So while the state might not prosecute you for open carry there, security could still kick you out or even trespass you if they choose to enforce private rules. Bottom line, this isn't a blanket green light. The right to carry comes with responsibilities, and you're still expected to know the boundaries. You can be legally right and still end up cuffed if you don't respect the posted restrictions or ignore the signs. And until the legislature steps in to align these rules with the new court reality, the safest approach is still to know where you can carry and when to cover up. Let's bring it down to everyday life. Your car, your job, and the space in between. If your firearm stays locked inside your personal vehicle, you're protected under Florida's long-standing gun in your car rule. That hasn't changed. Employers can't punish you for it as long as the weapon's secured and out of sight. The gray area starts the second you step out. One county may see open carry as perfectly fine. The next might treat it like a problem call. Same gun, same driver, totally different reaction. Inside workplaces, the divide's just as sharp. Some companies quietly told employees, keep it discreet. Others still ban visible firearms altogether. Legally they can, because property rules trump carry rights indoors. So here's the move. Use judgment and stay professional. Just because you can carry doesn't mean you should flash it everywhere. Keep it covered, keep it lawful, and document any issue that comes up. In times like this, discretion isn't weakness, it's strategy. Here's the part nobody likes talking about. Even though open carry's legal under this ruling, that doesn't mean you're immune from being detained, questioned, or even arrested. Remember, not every department got the memo, and not every officer interprets the law the same way. If you end up in that gray zone, the smart move is to stay calm and document everything. Don't argue on the spot. Let your lawyer handle it later. And if you carry regularly, this is the moment to make sure you've got legal defense coverage through something like USCCA or Armed Citizens Legal Defense Network. A 5-minute misunderstanding could easily turn into a $5,000 problem. It's also worth noting that some prosecutors may still try to test this ruling, especially in counties that disagree politically. That's why preparation matters. Know the case name, know your rights, and keep your permit or ID on you at all times. Bottom line, this ruling opened the door, but it didn't clear the path. You still have to walk smart, stay informed, and keep your documentation ready. The ones who get caught off guard aren't the ones carrying illegally. They're the ones carrying without a plan. You knew politics wouldn't stay quiet on this one. The second that ruling dropped, both sides lit up overnight. Gun rights advocates called it a victory years in the making, a course correction after decades of rights delayed. They're saying Florida finally lined up with the spirit of the Bruin decision, and that the Constitution's back in the driver's seat. On the other side, anti-gun groups hit the panic button. They warned it would turn public spaces into armed zones, pushed for emergency appeals, and demanded the governor take a stand. But here's the twist. So far, the Attorney General's office hasn't moved to challenge the ruling, which basically leaves the decision standing, at least for now. Meanwhile, media coverage has been all over the place, headlines shouting chaos, while the people who actually read the opinion see it as a carefully measured shift, not a free-for-all. And that's really where we are today. Florida caught in the middle of a political tug-of-war. The courts handed down a ruling. The politicians are still figuring out what to do with it. For gun owners, that means the noise will keep going, but the right itself just got a lot harder to roll back. So, where does that leave you right now? In short, cautious, informed, and prepared. If you're planning to open carry, know your county, know your sheriff's stance, and stay updated. Don't rely on internet comments, read the memo, know the case name, and keep copies of the ruling on your phone. It's not paranoia, it's protection. Second, keep your concealed permit valid. even if open carry's temporarily recognized. Laws can shift fast, and that permit still gives you a legal cushion if the courts or legislature tweak things again. Next, train like it matters. Don't just focus on draw speed. Learn de-escalation, retention, and what to say if law enforcement stops you. Confidence isn't about being loud, it's about being prepared when tension hits. And remember, this situation's fluid. Lawmakers could rewrite the statute next session, either to clarify or roll back what the court just opened up. Until then, your best defense is knowing the details better than anyone trying to argue them. What's happening in Florida isn't just a state issue. It's a test case for the rest of the country. Legal analysts are already saying this decision could become the new blueprint for future lawsuits in states with restrictive open carry bans. The logic behind it, using Bruin to challenge historical precedent, can apply almost anywhere. That means states like California, New York, and Maryland are watching this one closely, because it gives attorneys a clear model for striking down similar laws. It's also sparking quiet conversations among lawmakers in gun-friendly states. Some want to get ahead of the courts and rewrite their own carry statutes before judges do it for them. Others are worried that Florida's example could bring more federal attention and new political heat. But from a rights standpoint, this is momentum. Every time a court reinforces the original intent of the Second Amendment, it shifts the Overton window further back toward individual freedom. And that's not something easy to undo. So whether you live in Florida or 5 states away, this ruling matters. It's a preview of what's coming. A reminder that once the courts start applying constitutional text strictly, there's no going halfway. So here's the bottom line. This ruling didn't just shake up one state's laws, it reminded everyone that rights only matter if people are willing to challenge the system enforcing them. Florida's now standing at the crossroads. On one hand, you've got a court saying open carry is protected under the Constitution. On the other, you've got departments still acting like nothing changed. That gap between law and enforcement is where confusion and risk lives. But there's a positive side, too. This decision lit a fire under the conversation about what the Second Amendment really means in modern America. It pushed both sides to re-examine what bearing arms looks like outside a headline or political talking point. No matter where you stand on the issue, one thing's clear. This moment is bigger than Florida. It's about how far individual freedom still stretches when it's tested, and whether states will keep trying to narrow it or finally start recognizing it for what it's always been. At the end of the day, this isn't just another legal update. It's a reminder that our rights don't protect themselves. Every case, every ruling, and every citizen who stands up for their freedom keeps that protection alive. So whether you agree with open carry or not, stay educated, stay respectful, and stay ready. Laws will shift, politicians will argue, but responsibility and awareness will always be your best defense. If you live in Florida, take a minute to read the actual ruling yourself. Don't rely on sound bites, understand what changed and what didn't. Because the better informed you are, the harder it is for anyone to twist the truth. Make sure you like, subscribe, and drop a comment down below. Stay sharp.